Why isn't Judge Merchan considering sending Donald Trump to jail, even though he was convicted by a jury of 34 felony counts in New York? Is that right? Is that appropriate? Why is he tipping his hand already that on January 10th, he has no plans on sending Donald Trump to jail? I debate my partner, Ben Meiselas, about it. We take different positions. You might be interested in mine. You might be interested in his, or you might form your own. Either way, join us on Legal AF. Here's the After Dark edition.
Let's do that right now, Michael Popok, though, as it relates to the ruling in New York. And that was that Donald Trump will be sentenced on January 10th. Trump can't stop the sentencing from taking place. Another big loss, if you will. But when you read the fine print in the 18-page ruling, or in this case, when you get to page 17, it doesn't seem that the judge is inclined to really impose any meaningful prison time, or actually no prison time at all. While the judge on page 17, Judge Juan Merchan, says, finding no legal impediment to sentencing. And then he goes on to say that we should go through with this sentencing. Justice Juan Merchan just does say, when balancing the various considerations, and specifically that Donald Trump is now the president-elect, he talks about how he's inclined to do something that's called an unconditional discharge. And I want you to describe what that means. But just to quickly remind people what's happened here recently, you may say, did you talk about this recently on Legal AF? What we talked about before was Donald Trump filing a motion claiming absolute presidential immunity and saying that the conduct at issue, the hush money payments, the fraud, all of that was done in connection with the presidency and the office of the presidency, pursuant to the United States Supreme Court ruling. All of the fraudulent business records. Justice Merchan analyzed that in detail, and that's what we covered on the last Legal AF, or the Legal AF before that. Merchan's like, what are you talking about? Okay, porn stars, hush money payments before you were president. Like, this has nothing to do with anything about presidential duties. And even if you want to argue that some evidence that came in was during the presidency regarding the cover-up, I don't see how covering up private conduct now becomes presidential conduct. You've also waived your objections by not asserting them at the right time. And in any event, this is harmless, a doctrine called harmless error, even if I allowed some of this evidence in, because setting aside some of the small evidence about the cover-up, if you will, there was overwhelming evidence of your guilt. And so it was only harmless error if I allowed in any of this other stuff. So just to kind of situate people's minds just quickly, and I'm going to toss it over to you, Popok. Mm-hmm. There are federal courts and state courts in our system, okay? Federal courts deal with federal issues, federal crimes, and where there's federal jurisdiction. State courts deal with state crimes and state issues. So Donald Trump was charged by a district attorney, Alvin Bragg, with New York state crimes. That's why it's the people v. Trump, not the USA v. Trump. The people of the state of New York v. Donald Trump. And then within the federal and state court systems, kind of different systems in our federalism, there are appellate court. There's trial courts, appellate courts, and then the highest court. So when we were talking about the E. Jean Carroll situation, what we were talking about was an appeal by the Second Circuit Court of Appeals that oversaw a trial judge after a trial. And that trial court judge denied all of Donald Trump's motions after the trial to try to get rid of it. What we're talking about in the state court system is a trial court judge, Juan Merchan, rejecting Donald Trump's ability or request to dismiss. So then what Donald Trump would do after this is appeal to the appellate division in New York. That has not yet happened yet. But I just want you to all have a framework here, because we talk about federal, state, and I'm oversimplifying things, but I just want people to situate their minds with these frameworks. Popok, tell us what Justice Merchan did.
Yeah, and I practice in New York, and so I'll give you my background. I think you and Karen did a great immediate hit on the sentencing yesterday, or the sentencing thing. We weren't really expecting we were expecting the rejection of what we call the New York a Clayton motion, which is there's been such injustice that for justice's sake, my convictions should be thrown out type of motion that Donald Trump filed after he was elected. That was not a surprise. I was actually surprised it took this long because a couple of weeks ago, Judge Merchan tipped his hand by denying with equally impressive intellectual gifts and integrity, dismissing the immunity argument, that there was some sort of immunity at play or supremacy at play because Donald Trump, for a very small component after the conspiracy, which led to the payoff of Stormy Daniels and the 34 felony count conviction, pardon me, by the jury, very, very small shreds of evidence and witness testimony had to do with him after he got elected, i.e. he successfully interfered with the election and beat Hillary Clinton. And the judge analyzed all that and the immunity came out. I said, all right, great. I think he's going to reject Clayton like 10 minutes later. And it did take him a little bit longer. When he rejected the Clayton motion, mainly because there's 10 factors that you have to analyze and then show on balance that you win on the Clayton factors. And Donald Trump's lawyers, who are soon to be given plum assignments in the top leadership of the Department of Justice and the Solicitor General's office. I'm talking about Todd Blanche, Emil Bove, and John Sauer, but they haven't covered themselves with any glory in New York practice. In terms of the 9 or 10 factors, they didn't analyze any of them. The people, the Alvin Bragg side, the Manhattan DA side, went through methodically in like 100 pages why they fail every factor. The judge then went back through the 10 factors and said why he's rejecting the Clayton motion. He's not throwing away a 12-0, 34-count conviction that a jury worked very hard on. I was expecting that. In the back of it, the last page, he then turned, and a page before that, Judge Merchan then turned to sentencing under a title listed as sentencing. And there he did what you in your world in California, you guys are familiar with. We're not in New York, which is sort of a tentative ruling where the judge tells you like in advance where his head is at, and then you have to try to convince him otherwise at the oral argument and further briefing. And what he said was, I've started to balance these competing interests of a person now elected president, the start of an administration, the immunity issues that may be in play, and a sentence. And he said, I reject some of the arguments made by the people, which is Alvin Bragg. Particularly, I'm not going to use what's called the Alabama rule in New York. I'm not going to just mark down that he's a felon and then pick up 4 years from now and do sentencing. Because I think that Donald Trump, as any criminal convicted person, has the right to an appeal. And I'm not going to delay the appeal 4 years. If he wants to appeal, he can appeal now. He needs some sort of definite sentencing issue now. I also, for those same reasons, reject sentencing him now, but delaying the start of the sentence until after he comes out, which was that was the Popok one. I said he was going to be sentenced before the inauguration. Looks like that's going to happen, but that he'll defer the sentence. I wanted to be about a year and a half, 2 years, until after, of course, he starts it after he comes out of being the president. They didn't like that one either. And what he said was, I think the proper balance, having found no president-elect immunity, no supremacy clause immunity, no other immunity here, is that I'm going to, and I'm going to wait for briefing, and I'm going to pull all this together on the 10th of January. That's the date he set. And Donald Trump, you can zoom in or you can appear in person, but we're doing it on the 10th. And where my head is at, so everybody knows, is that I'm going to do what's called a unconditional discharge, which is that the felonies, 34 of them, stay on the books indelibly forevermore. That is Donald Trump's scarlet letter. He is a felon in New York, convicted, and the judge is not discharging that or taking that away. However, when it comes to the sentence, without condition, I'm going to discharge any punishment, meaning there's not community service, not picking up papers on the highway, nothing. That is, but he will live under the scandal of having been and always will be a felon in the state of New York. He says, I'm going to take briefing on this. And I've done a hot take where I'm encouraging the Manhattan DA's office to cross appeal on this issue, because I think it's an insult to the jury. I think if you told the jury when they were deliberating that you're going to listen to weeks and weeks of testimony, you're going to convict the guy on 34 felony counts after listening to the overwhelming, beyond a reasonable doubt standard of evidence. And then at the end, the judge, because the guy got elected president, is going to literally get a get out of jail free card, and he's not going to suffer any consequences other than the trial itself and being labeled a felon. I think they would revolt. And I think they find it revolting today if the press and the media tracks down the jury and asks them their opinions. I'm sure that's going to be a new wave. Maybe we can get some on the Midas Touch Network. If I were the jury, I'd be pissed off. And I think it sets a terrible precedent. I think the Manhattan DA spent all this time and money getting the first conviction, and now appears to be only conviction of Donald Trump. And they owe it to the American people and to the people of the state of New York to try to convince if they can't convince Merchan on the 10th through briefing, then get it up to the First Department Appellate Division in New York, in Manhattan, which is that intermediary appellate court that goes first, and then up to the Court of Appeals. I don't see any of these issues. Well, let me back up. The Supreme Court could stick their noses in this case because of the immunity and supremacy clause issues if they wanted to. Donald Trump's got a few days here to file an emergency appeal off the weekend. Could even be, tomorrow. He's done okay with emergency appeals at the appellate division First Department. He's occasionally he draws this one duty judge who sides with him time and time again. So he could get a stay of the sentence while the appellate court decides whether, now that Merchan has tipped his hand, whether Merchan is in the right is on the right ballpark or not about his thinking about sentencing, or he should have granted the Clayton motion. So I assume we're going to get a emergency appeal on the judge's failure to have granted the Clayton motion to discharge the convictions on the various factors. I think he loses that, by the way, but I think we'll see an emergency appeal. And the question is, either can they cram the emergency appeal into a full panel between now and the 10th? Will they do what they've done in the past sometimes with Judge Merchan, which is they put a pin in it, they do their own briefing, they delay. Now we're past the inauguration and all of that. That could happen. And then Donald Trump could try a lateral and try to do an emergency appeal to the United States Supreme Court on these issues, because he's raised through his soon-to-be number 2 in the Department of Justice, number 3 in the Department of Justice, Solicitor General. He's raised all these issues. But the first stop on that train, as we reinforce time and time again on Legal AF, is Judge Sotomayor, who sits over all things New York and federal. And she's going to have to either make the decision on her own, no, or turn it over because of some of these bigger implications. I'm not sure that the Supreme Court, I want to hear your opinion, of course, Ben, I'm not sure the Supreme Court is that ready to wade back into immunity. One last thing before I finished. He did drop a footnote, Judge Merchan, footnote number 2 in his order, in which, and we're going to tie it on the other side of our ad break, to the Justice Roberts annual report. That's already paying dividends, because when Roberts talks about attacks on the judiciary coming from public actors, there's only one person you can think about, is Donald Trump. And the judge spent considerable ink chastising Beauvais, Sauer, and Blanche about crossing the line in their zealous advocacy and calling the court and the prosecutors effectively calling out what they claim was criminal activity, which is a big no-no. Can't just throw that around unless you have some evidence of it, and the judge took them to task on that. At the end of the day, though, I do think, and I want to hear your opinion, I do think Merchan sort of lost a little bit of his balls here in the sentencing area. I want to hear why you think he went to unconditional disposition as where his head is at, and what do you think the Supreme Court's going to do about it?
I guess let me go in the order the reverse order. You mentioned at the end, Justice Merchan, did he kind of lose his steam? Was he scared? What was happening here? I mean, look, I think that Justice Merchan realizes that with all practicality, while Trump is in office, there is really no chance of Trump actually being incarcerated or imprisoned or thrown in jail. And also, I think that he worried that if he imposed some sort of fine or penalty or something else like that, what it could do is allow that to be an issue on appeal, call into question the overall judgment, and could the United States Supreme Court, which I think Merchan is focused on what the Supreme Court is going to do, even beyond what the appellate division and the highest court in New York, which in New York is called the Court of Appeals because they are the Court of Appeal because they like to be tricky with law students. And it's always a funny thing. In New York, the lowest court is called their Supreme Court, and their highest court is their Court of Appeals. And then they have appellate divisions, which is their intermediary courts. But I think the audience here by Merchan is that emergency appeal to the Supreme Court. I think Merchan feels comfortable that his ruling falls outside the outer perimeter of any absolute immunity, core constitutional functions, official acts. And then he buttressed his decision. Remember back in our analysis with all of those various layers of shields and protection. Well, okay, well, you waived your objections, number one. Number two, you don't get absolute immunity. Number three, I'm the trial court judge. I find it harmless error regardless. So he gave three ways the Supreme Court can rule against Donald Trump. And I think that his audience is the Supreme Court. So I think he's thinking, look, at this point, an unconditional discharge, even though Trump won't serve jail time, it'll make the historical record of what went down when Trump appeals this to the Supreme Court. Trump's buddies on the Supreme Court may not want to further extend and entrench this absolute immunity doctrine to like hush money payments to porn stars and fraudulent business transactions, because you would see him in a reading of the opinion that falls outside of it, and don't give them an excuse to do anything to hand Trump a potential win here. And I think he also realizes, look, in 4 years anyway, Trump's going to be what, 82, 83 years old, maybe going on 84, whatever it is. When I think that, Merchan's thinking to himself, okay, he's 84. By the time sentencing gets set, if you delay this to when Trump's 84, you're going to have a new district attorney. You're going to have a new team. So sentencing would probably start a year after. So you figure then Trump's, 85 years old. And I think Merchan's just thinking in his own mind, going through those reps. You wouldn't have, remember, a unconditional discharge is a final judgment. Okay. So even though Donald Trump was convicted of felonies, there's not a final judgment until that sentencing happens. So if he just delayed things until 2029, Trump can go around and say, well, technically, even though I was convicted by a jury, I'm X, Y, and Z. And I think Merchan is worried too. What's the next judge? If I'm not a judge, what's the next judge going to do in 2029? So Popok, I think it was rooted in those considerations, which brings me to your other point. I think the Supreme Court, though, is, if and when they hear Trump's appeal with the unconditional discharge, I actually think that they, call me naive here, but I think that they won't side with Trump, that the conduct in New York was subject to the absolute immunity. I think the Supreme Court and John Roberts, and we'll talk about his annual report, I think he wants to give kind of the, Nixon v. Fitzgerald v. Clinton v. Jones test. And for those who don't remember, in the civil context, you have Nixon v. Fitzgerald. You couldn't sue Nixon because that was viewed as an official act, even though he fired someone wrongfully and as part of a cover-up. That was part of the executive branch. But in Clinton v. Jones, that was, a private sexual incident affair with Clinton and Paula Jones. And the court said that's clearly outside the outer limits of civil immunity. So I think that John Roberts is looking to kind of say, well, yeah, I gave you absolute immunity a la Nixon v. Fitzgerald, but now I'm going to give you New York v. Trump, which is my Clinton v. Jones criminal corollary. So that's my thinking there, Popok.
Yeah, I understand it. And I know the judges, and I agree with him that Trump and others should have the right to appeal now and not wait around in 4 years. I just don't think, I think he could have gotten away with an imposition of a sentence of a year and a half, which is, based on the survey of other similar convictions for this type of fraud, this type of business record fraud, and this type of in furtherance of another crime. Norm Eisen and other groups have done a pretty good job at looking at, the hundreds and hundreds and hundreds of cases. And there's, of course, his is completely unique because there were so many counts. And also because it interfered with an election and he was a candidate for the presidency. I think the proper message that society through the judge should have sent is a year and a half in jail to be served after he comes out in 2029, regardless of age. We're talking about a year, and then have it there and let the appellate courts do their thing. Let him argue he shouldn't get anything and he shouldn't be a felon, and let the Manhattan DA argue for more or less. I mean, look, we covered a lot of Jan 6 sentencings, a lot since at one point it was my bread and butter. It was like all I did in hot takes for weeks about 2.5 years ago was the beginnings of the Jan 6 sentencings, because they were so important to America to understand how the justice system was handling insurrectionists. And there were times when the federal prosecutors, the analog for the Manhattan DA, agreed with the judge. Sometimes the judge went higher than their recommendation. A lot of times they went lower, and they had to make decisions about whether they were going to appeal the judge because it was just too low. And I think from an institutional standpoint that the prosecutor should not take this lying down. I agree with the way you've analyzed it. I'm not saying you're coming out the wrong hole. It's just that I think that there's a bigger public policy here and a public justice system issue here that needs to be pursued by the prosecutors, and they can cross appeal. If Donald Trump appeals, I'm not a convict, they can cross appeal. You're not getting a high enough sentence, or your unconditional discharge isn't going to do it for us. And I think that's where we're going to see what Alvin Bragg is made of, and what his political and tactical strategic decisions are here moving forward. But I know it's not what we all wanted. It's not what the audience on this channel wanted. I got what I wanted in the terms of having a sentencing likely, unless the appellate court steps in before the inauguration, but not any type of. And why do you think? What was your? I have a view. Why do you think, Ben, the judge, because they don't usually do this, tipped off where his head is at in sentencing so in advance? To both sides. Why do you think he did that?
I think it's to both sides. I think it's to the public. I just think it is to set the tone that this is Donald. If this is something you really want to appeal, I'm not, it's a big deal. I mean, you're going to be doing, because it would be, it's a bombshell if he doesn't soften the blow by saying that that if he just said, I hereby sentence you, everybody would be thinking on January 10th, this guy is going to get thrown in jail. This guy's going to get thrown in prison that day. It would probably fuel absolutely an emergency appeal right away to the Supreme Court. And then the Supreme Court may intervene, because it's like you're going to throw someone who's in their transition into prison. So I think he's sending a message, to all of the courts that and the public, because imagine if he said sentencing to, and I hereby sentence you to nothing, it would cause unrest. So he's giving a lot of messages given the unique circumstances. But Popok, look, let's be real. I just want to be on, look, Alvin Bragg is not going to pursue incarceration. He isn't. And how do I know that?
After? I mean, nobody on this channel believed or argued that he was going to go to prison as president-elect or during the 4 years. But you don't think Alvin Bragg is going to argue that he should go to prison when he comes out?
No.
Okay. All right. We're going to see. We'll see the briefs, and you and I will bet a lunch on it.
While this court, as a matter of law, must not make any I'm reading from page 17.
Yeah.
While this court, as a matter of law, must not make any determination on sentencing prior to giving the parties and defendant an opportunity to be heard, it seems proper at this juncture to make known the court's inclination not to impose any sentence of incarceration, a sentence authorized by the conviction, but one the people, meaning Alvin Bragg, concede they no longer view as a practical recommendation. As such, in balancing the factors, then he talks about an unconditional discharge. So Alvin Bragg has already set in motions that now, to your point, Popok, perhaps Alvin Bragg was saying during the next 4 years,
Right.
But Alvin Bragg will take the unconditional discharge because one of the things that Alvin Bragg even suggested was the Alabama rule, which is basically treat Donald Trump like he's a dead person, the Alabama rule. Sentence him, but then say, you're dead to me. So you can't do the time. So one of the options was the Alabama rule, which is do a fake sentence and then be like, we can't sentence the dead person. And so that's my view, but we'll see. I'd like to tell people that I think he can be incarcerated, but I don't think it's going to happen.
Welcome back. Legal AF. It's the OG podcast. It's on Wednesdays and Saturdays at 8 p.m. Eastern time here on the Midas Touch YouTube channel. We do a live record those days. Then it's on all podcast platforms. It's about an hour long. We sit at the intersection of law and politics so you don't have to, and we don't blow smoke or sunshine. If you know about Legal AF, I appreciate you very much. Take that clip, send it off to friends and family, ask them to join our journey as part of their own and help us expand our audience. Maybe you don't even know about Legal AF. You only know my work, Michael Popok, here on the Midas Touch Network or on Legal AF, the YouTube channel. I invite you to join the full-length podcasts. You can also pick us up on all audio podcast platforms. So until my next Legal AF, this is Michael Popok reporting. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.